just cross over a bit live to Mombasa County, where I said 150 judges from the different courts are currently holding their annual conference, and our reporter Kevin Mutai is on that beat. Let's listen in.
Transparency requires to receive feedback as a way of improving our service delivery. To this end, we arranged as part of this colloquium to have an engagement tomorrow morning with some of our key stakeholders to get some form of feedback on the services that we offer. They will not touch on any live issues in court, but will generally talk about the services that we render. This is because some of the decisions we make on matters that are brought before us have an impact beyond the parties who appear before us. Even beyond the colloquium, we must always be open to receiving some feedback on our work. When some concerns are expressed regarding inconsistencies in the granting of bail and bond and in sentencing, for example, it is not always an attempt to question our exercise of discretion. As I have said, we must vigorously defend our decisional independence, but also always recognize that it comes with a lot of responsibility on our part. It must not be brazen, whimsical, or random. We must act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Fellow judges, ladies and gentlemen, hearing, determining and disposal of matters is our core business. Efficacious and efficient disposal of matters remains our core promise to the people of Kenya. Some cases take inordinately long to resolve. We must therefore never tire of interrogating the issue of backlog clearance. When we met here last year, we talked at length about the need to improve the speed of the resolution of cases in all our courts. At that time, there were over 110,000 cases that were more than 5 years old. In all stations developed action plans aimed at bringing this number down. We had hoped, and I made repeated promises to the Kenyans regarding this, to have all of them cleared by the end of last year, using strategies such as service weeks. We were also looking at increased use of technology as a way of speeding up our work. So where are we at the moment? As of June this year, the number of cases older than 5 years in all the superior courts, that is the Court of Appeal, that is the Supreme Court, the Court of Appeal, the High Court, the ELC, the ELRC, had come down from 110,000 to 15,278. This is no doubt a remarkable achievement, and I want to take this opportunity to congratulate all of you colleagues for this splendid job. While tracking the movement of all cases, we have found a number of interesting trends, some of which are difficult to explain. I would like to bring to your notice, for example, that it takes, on average, 1,235 days to dispose of criminal matters at the Court of Appeal. That is on average, and an average of 727 days to conclude a civil matter in the same court. However, the trend is inverted at the High Court, where criminal matters take a much shorter time, 522 days on average, while civil matters take a little longer, actually much longer, on average 1,057 days. At the ELRC, cases take on average 849 days, while at the ELC, they take 1,141 days. While all these are an improvement from last year, they are still not as good as they should be. The magistrates' courts, for example, take an average of 665 days to conclude both civil and criminal matters. Is there something we should learn from the magistrates' courts on this? That we should reflect and think about that. Another matter of significant concern is the variation in performance between the different courts. For example, whereas the ELRC had an average overall case clearance rate of 160%, and the High Court 134%, the Court of Appeal managed only 49%, meaning that the build-up of backlog has been continuing. For the Court of Appeal, this is of course attributable to the significant shortfall in the staffing levels, a challenge that we recently addressed with the recruitment of 11 new judges. At the Supreme Court, we had a clearance rate of 93%, even though we still managed to bring down the backlog by 7%, and of course with no cases older than 5 years. The ELC had the highest change in backlog clearance, with the total number of all the cases coming down by 19%. Some of the stations have had extremely good performance. The Milimani Civil Division, for example, had a case clearance rate of 583%, leading to a 21% reduction in the overall case backlog count. Compare this with Narok. Compare this with Narok, which had about 38% case clearance rate and 106% increase in the case backlog count. Just so that you appreciate the disparities further, let us contrast the performance at the Kiambu High Court, which had an overall productivity rate of 1,067, with that of Kapenguria, which had 64. Just to be clear, I would like to make this clear so that we understand each other, that the difference between case clearance rate and the productivity rate is that whereas the former is a percentage of the resolved cases in a particular court station in relation to the filed cases in the same court, productivity refers to the total resolved cases divided by the number of judicial officers at the station. So you can see why, in relation to productivity, the difference between Kiambu's rate of 1,067 and the Kapunguria's of 64 is a matter of great concern, particularly when the latter ended up with a significant increase in its backlog numbers. I'm not raising these figures to criticize or embarrass anybody, but I would like you to spend time, if not in the main sessions, but then on the sidelines, to borrow a leaf from each other, from those stations that have done well, so that we can be able to perform in a relatively uniform, at a relatively uniform rate. So, ladies and gentlemen, let's look at the stations which have done well and see what we can emulate from them. The adjudication of justice requires a knowledgeable judiciary, a judiciary that remains aware of the evolving issues facing the world in which its clients live, and a judiciary alive to the emerging jurisprudence in various fields. This year's program will also offer an opportunity to interrogate the emerging jurisprudence on global warming up and climate change, as well as some touchy issues such as what we hope to explore under the topic, the judicial approach on sexual offenses and the age of consent, facts and figures, as well as challenges. Fellow judges, as you know, one of the transformation elements we have been pursuing vigorously has been digitization of our key processes. Over the last year, the judiciary has made significant progress.
All right.